What up, though? What up, though? This your boy Tay Biz TV, man, coming at you, man. I hope y'all saw the thumbnail. Got us some news today about Judge Glanville's recusal motion that was filed, or I should say the motion in the order that was filed this morning, 11:26 a.m., man. So, yo, this is kind of crazy. I have not read this document yet. I haven't read it yet. I'm gonna go over the document and look at the details and see what's going on with it. It's only a 10-page document, so it's not a very long read. But your boy Glanville has been officially removed completely from the YSL trial. The motion that Young Thug had was to recuse him from having all further dealings with the YSL trial, and he has no more dealings with the YSL trial. So go ahead, hit the like button, man. Let's go ahead and do this. Hit the like button. Let's get it in. Let's get it popping. Let's go ahead and get this. Let's go ahead and read this, man. I don't want to waste too much time with this. All right, let's go ahead and read this. Maybe you just coming in, hit me with a what up though in the chat, and let's get it in. Let's get it in. Hope everybody's having a great day. I couldn't wait to come home, man. I couldn't wait to come to the crib and get this and get it popping, man. I could not wait. Because this right here is interesting, man. This is the case. Glanville is no longer a part of the YSL trial at all. He has no further dealings at all with YSL. So we're gonna go ahead and read this document real quick, and we're gonna see what's going on with this here, man. All right. So it was filed this morning at 11:26, July 15th. Today, and it says in the Superior Court of Fulton County, state of Georgia, the state of Georgia versus everybody, as we know who they are. It says order on motions to recuse Judge Glanville. All right, here we go, man. I'm excited about this. Let's hit the like button, man. Let's go ahead and get it popping. I'm excited about this. Share this real quick. Let everybody know that Tay Biz TV is on it right now, and we are going to talk about this right now. A lot of us are talking about it. I know the lead is. I know that Cat Not Williams was on the shout out to Cat Not Williams. I mean, it's look, it is going down. Abundance, thank you for jumping in, man. Welcome on everyone. To everyone, it says please hit the like button on your way in. Come on, let's get it in, let's get it popping. Put a 1 in the chat if y'all ready to get it popping. Put a 1 in the chat if you're ready to get it going. All right, here we go. So just a couple ones here. Okay, here we go. So we're going to go ahead and says order on motions to recuse Judge Glanville. All right, this case is before the court to consider. Okay, hold on. Let me get it popping here. Hold on. There we go. I want to blow it up a little bit so everybody can see. You know what I mean? Turn this fan. Everybody can see what's going on. So the order on motions to recuse Judge Glanville. This case is before the court to consider various motions to recuse, including defendant Diamante Kendricks, that's Yet Gotti. Motion to recuse Chief Judge Ural Glanville, filed on June 12th. Caleb Bumpus's motion to quash the show cause order and or to recuse Judge Glanville as the second motion that was supposed to be reviewed. And also we have the defendant, Young Thug, Young Slime, motion to disqualify and recuse Judge Glanville from all further dealings in the above referenced case and an amended supplement. Says here the specific facts necessary to determine these recusal motions are well documented in affidavits, court filings, certified transcripts, and video recordings available on YouTube. Having considered the record evidence and applicable case law, the court finds as follows. And it says his little footnote here says this court previously considered and denied the defendant Kendrick's motion to disqualify Fulton County Superior Court judges from ruling on recusal motion and the portion of defendant Williams amended supplement that sought this court's recusal. Okay, so the footnotes here is saying that they denied the fact that they were going to disqualify all of Fulton County judges. So that makes sense based on who they picked. And we're going to talk about who's on it now. And then and it says here also that the portion to recuse the court is also been denied as well, which she did do that as well. I think we read that too. All right, it says findings of fact. It says these recusal motions arise out of a multi-defendant prosecution brought by the Fulton County District Attorney's Office, alleging gang activity and associated crimes. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7, 2024. The motions to recuse all arise from the same circumstances related to state's witness Kenneth Copeland. The state's witness Kenneth Copeland. On June, the little Woody. On June 7, 2024, the state intended to call Kenneth Copeland to testify. Prior to his testimony, counsel for Mr. Copeland, Jonathan Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Mr. Copeland. Remember, this was use immunity, so they could impeach him and do all that kind of stuff. So that's why they're trying to do that now, even though the case is on hold. Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville also advised that if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. After that discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Now, what is she talking about? Wait, she's talking about the transcript. And hold on. I think she's talking about the transcript. Because he already pled. I think she's talking about the transcript here, because it says here, after that discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. That was only in the ex parte meeting. So she kind of jumping the gun a little bit in her order, man. Let's read the rest of this though. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the fifth." Judge Glanville excused the jury. Yeah, that was on the 7th. However, still, this part right here where he discussed something with his lawyer, that was pre him going on the bench. That was way before that even happened. Melnick had jumped in and all that kind of stuff. So, yeah, she jumped the gun just a little bit. It says here, Glanville excused the jury and then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, June 10th, and at which time Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Glanville indicated he would revisit the issue with Mr. Copeland on Monday, June 10th at 8:30 a.m. No, he did not. Actually, he did not indicate that. He said he would come back. He did not indicate that there was going to be any type of revisiting at 8:30. Otherwise, the entire court would have been there. Some of this ain't right, man. Already, I'm seeing some stuff miss. I'm seeing some stuff already, y'all. Hold on. Let's deep. Okay, Krause. Let's dive into this now. Judge Glanville indicated he would revisit the issue with Mr. Copeland on Monday, June 10th at 8:30 a.m. That's not accurate. And court was adjourned for the day. Yeah, that's not accurate. That ex parte meeting was not mentioned in open court. On June 10th, 2024, at approximately 9:10 a.m., Judge Glanville met with counsel for the state, Adrian Love, and stand-in counsel for Mr. Copeland, Kayla Bumpus. The meeting took place in Judge Glanville's chambers. You mean the sacrosanct chambers? Counsel for the trial defendants did not participate in the meeting and were not aware that the meeting was taking place. Okay, then, so how can he indicate anything? And he never did. The transcript reflects that Ms. Love told Judge Glanville that she wanted the meeting to both impress upon Mr. Copeland the risks of refusing to testify and allow Mr. Copeland to ask questions before he testified. Ms. Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Ms. Bumpus, Ms. Love, and Glanville also discussed the scope and effect of state's grant of immunity to Mr. Copeland. Mr. Copeland was then brought to Judge Glanville's chambers, where he spoke with and asked questions of Ms. Bumpus, Judge Glanville, and Hilton. Two investigators from the DA's office and multiple deputies were also present, as well as one or more members of Glanville's staff. Of course, the court reporter was there who took down the conference. The certified transcript was filed into record on the 1st. We know that. Counsel for the state who had joined the meeting. During that time, the state advised Mr. Copeland that he could remain in custody until the conclusion of the trials of all defendants in the case, not just the 6 currently on trial. Judge Glanville discussed OCGA 24-5-507 with Mr. Copeland and his rights and responsibilities after grant of immunity. Mr. Copeland spoke privately with his standing. I mean, she's missing a lot of stuff in this, man, but it's okay. Mr. Copeland spoke privately with his standing counsel, Ms. Bumpus, and then advised the court that he would testify. Ma'am, this is a very light way of putting this. This is a very light way of putting this. This man was coerced, okay? This wasn't no discussion. You know what I'm saying? This wasn't no powwow. This man was coerced, man. After the meeting, and immediately before Mr. Copeland was brought out to testify, defendant Williams' lawyer Brian Steele advised the court that he was aware of the in-chambers meeting that morning. Mr. Steele objected to the ex parte meeting, and a lengthy colloquy occurred between Mr. Steele and Judge Glanville. In other words, they was arguing, in which Judge Glanville inquired how Mr. Steele become aware of the chambers meeting. Mr. Steele declined to reveal the source of his information, and Judge Glanville held him in contempt. We all saw that. That's when the Gacto came through. He was held in contempt. Let's see where we are here, though. Mr. Steele was allowed to remain in the courtroom on behalf of his client, defendant Williams. Ultimately, Kenneth Copeland did testify on June 10th, 2024, and was later released from custody. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. An amended show cause order was later entered, setting July 1st, 2024 for an in-camera review of the transcript of the ex parte meeting. The first motion to recuse filed by Diamante Kendrick on June 12th, 2024. And there's a footnote there. We'll get to that footnote in a minute. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the allegedly improper and coercive ex parte meeting with the state, which allegedly improper and allegedly coercive. Okay. Hey, did you like that? My take, he fired. Hey, he fired. He fired, man. Let's go. All right. On June 14th, 2024, Judge Glanville denied the motion. If you like the thumbnail, put a 1 in the chat if you was filling the thumbnail real quick. On June 14th, 2024, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and on a cursory review contains assertions of fact to support the allegations of bias and partiality. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chambers meeting, the affidavit was legally insufficient, and the motion to recuse did not require referral to another judge for consideration. All right. So basically, she's just reiterating the fact that she kind of goes with the fact of, it was no actual evidence of anything coercive or anything like that. So everything was alleged. So therefore, she's rocking with Glanville on that, which is crazy to me. On June 14th, 2024, Bumpus then filed a motion to quash the show cause order and or to recuse Glanville from presiding over any contempt action against Ms. Bumpus resulted from alleged disclosure of the ex parte meeting. Well, yeah, that makes sense because he's a witness. He's a witness to his own meeting, remember? Duh. On June 17th, 2024, Jeffrey Williams filed his motion to recuse Judge Glanville. Divorce from its hyperbole for real? What? Mr. Williams' motion and supplement also seek to recuse Judge Glanville because of his involvement in the ex parte meeting. Come on, hyperbole. Was it really hyperbole? Which Mr. Williams also alleges was improper and coercive. Absolutely. You cannot give a sworn witness legal advice if you're a judge. And you especially cannot do it in a private meeting where the defense is not even there. Like, come on now. It says here, technically, Mr. Steele's counsel moved to recuse Judge Glanville from further handling of the contempt action during the June 10th proceedings. However, that motion was made orally, and it is not before this court because Mr. Steele's contempt matter is currently pending before the Supreme Court. Although, and then number 6 footnote, although referred to this court for consideration, Bumpus's motion to recuse is both premature and moot because Ms. Bumpus has not yet been held in contempt, and because on July 1st, Judge Glanville canceled the show cause hearing. Says here, Mr. Williams' motion alleges both actual bias and the appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became embroiled in a controversy. Look at her describing. You talk about hyperbole. Look at this. Embroiled in a controversy when he held Mr. Williams' lawyer, Brian Steele, in contempt. Yeah, okay. Embroiled is it's a way deeper word than embroiled that happened. On July 1st, the day appointed for the parties to review a redacted transcript. Whoa. On July 1st, 2024, the day appointed for the parties to review a redacted transcript of the ex parte meeting. Hold on. Are we reading this correctly? Judge Glanville announced that he was releasing the entirety of the transcript of the ex parte meeting and was taking judicial notice of and making a record regarding certain matters associated with the ex parte meeting. It says redacted right here. This says the day appointed for the parties to review a redacted transcript. She's saying Glanville showed and released the entirety of it. Did she? I mean, did he? Come on now. Did he really? We read the transcript together, y'all. Did we see some redactions? Well, not redactions, but we saw some omissions. We definitely saw some omissions, okay? Most of what Judge Glanville relayed was a collation of record evidence about the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for an ex parte meeting. In addressing the circumstances in the contempt against Mr. Steele, Judge Glanville explained the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. You know, the sacrosanctity. Yeah, okay, sure. Judge Glanville advised that he had not instigated an investigation into surveillance footage, but he had reviewed such footage for timeline and security. He tried to keep some in his back pocket. Judge Glanville then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Judge Glanville also questioned defendants' right to be present at the ex parte meeting because the issue under discussion was between the state and a witness who was represented by counsel. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motions filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpus were being referred for consideration by another judge in accordance with Uniform Superior Court Rule 25.1 through 25.7. The motions to recuse were then assigned to this court for consideration. Now it says legal framework. Legal framework. Here we go. Motions to recuse are governed by a specific legal framework outlined in Rule 25 of the Uniform Rules of Superior Court. A party seeking recusal must file a timely motion supported by an affidavit with clearly stating facts and reasons for the belief that bias or prejudice exists. The affidavit must be definite and specific and describe circumstances of extrajudicial conduct or statements which demonstrate either bias in favor of any adverse party or prejudice toward the moving party in particular, or a systemic pattern of prejudicial conduct toward persons similarly situated to the moving party, which would influence the judge and impede or prevent impartiality in that action. So basically here, look, we talked about this before remember we discussed the objections and how the state was getting they was getting the overruled objections all the time. They was overruling every objection that the defense was almost doing, even if it was hearsay or even if it was, ask and answered or speculation. It was overruled. It was crazy. USCR 25.2 bare conclusions and opinions are not legally sufficient to support the motion or warrant further proceedings. Once such a motion is filed, it is the duty of the assigned judge to temporarily cease to act upon the merits of the matter. That's exactly what's supposed to happen. Like the lady did in the Alec Baldwin Russ trial. There was immediate hearing right then and there on day 3 because it was a motion to dismiss the case. Cease to act upon the merits of the matter and assess the timeliness and legal sufficiency of the affidavit and alleged facts. USCR 25.3. If all 3 criteria are met, i.e., the motion is timely, affidavit is supported, and facts alleged might warrant recusal, another judge shall be assigned to hear the motion to recuse. When considering a motion to recuse, the assigned judge should be guided by Rule 2.11 to 11 of the Revised Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. Case reference for that. The standard is objective. From the perspective of a reasonable, fair-minded, and impartial person, rather than the affected judge or other interested parties. Okay. If a motion to recuse satisfies the 3 threshold criteria, the assigned judge must refer the motion for reassignment and may not oppose the motion. So you cannot rule on your own motion. When it comes to recusal, you have to cease and give it over to somebody so that way they can review it and then they can go ahead and judge this particular motion, which is what's happening. I mean, the motion to recusal was like 3 times, man. It's crazy. The judge whose recusal is sought may not respond to the motion or attempt to refute the allegations, which stand denied automatically, no matter how false or even defamatory the judge might know or perceive the allegations to be. A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without that defense itself becoming a bias for recusal. Unbelievable. A judge has no interest in sitting on a particular case. At most, his interest lies in protecting his own reputation. You see what I'm saying? So you can't try to clean yourself up. You can't come out the mud clean, man. His efforts at defending himself against a motion to recuse will inevitably create an appearance of partiality. One reason is that if he defends himself, he becomes an adversary of the movement for recusal. This adversarial posture may create an antipathy which persists after the motion to recuse is denied. And then they cited some more cases here. Analysis and discussion. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit. In transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, i.e., that the recusal might be authorized if the facts alleged in the motion were assumed true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. What? Ain't that crazy? So she don't see nothing wrong with the ex parte meeting. You see that? It is worth noting that this court agrees generally with Glanville that the ex parte meeting basically was proper. Wow, man. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. You got to be kidding me. You didn't. So she saw no coercion in that transcript about jail time, about not only, all the jail time, not just the 2 years or whatever, all the jail time. Who knows how long that would have taken. And that's not coercive, please. However, in his order denying defendant Kendrick's motion and in the process of making his record on July 1st, 2024, Judge Glanville added facts, provided context, questioned the veracity of allegations, and otherwise explained his decisions and actions and argued why those actions were proper. That's what he did the day we looked at the video and we saw him listing all the timestamps of all that kind of stuff. I think we did a video about that as well, where he had to move the case, the recusal, to someone else. Hey, my take. Yeah, right. She want that donation again. Right. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is as objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. Well, he did that for sure. Remember, he was embroiled earlier is what we read, right? In presenting his presenting his record as to the recusal issues and in ruling on Kendrick's motion, Judge Glanville evaluated and accepted the truth of his own factual allegations mandating his recusal. Yeah, like after the third time, sure. The court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied. Come on, man. He's not biased. Look at Krause. Like he did give me $2,000. Or was it 2,500? Yeah, it was 2,500, 2,000, 2,500, something like that. He did give me that money, so I don't think he would be unfair. Even if it's denied, I don't think he would be unfair. That's a prerequisite to what's about to happen. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case. Oh, you see the prerequisite? Judge Rachel Krause just did a Stephen A. Smith. Okay, she just pulled a Stephen A. Smith right here. She said, look, I have no doubt, this court has no doubt that the chief judge, I know he can and he would probably continue presiding fairly over this matter, even if it was denied. Okay, I'm pretty sure he would do this. But because of the public's confidence in the judicial system, we want to make sure that we do everything proper. We're going to excuse Judge Glanville from further handling this case. Based on the foregoing, this court hereby orders as follows. Number one, defendant DeMonte Kendrick's motion to recuse Chief Judge Ural Glanville is granted. Hold on. Number 2, Caleb Bumpus' motion to quash the show cause order and or to recuse, I'm sorry, not rescue, my lord, recuse Judge Glanville is denied as moot. Wow. That's interesting. Hold on, that's very interesting. So Caleb Bumpus' motion to quash is denied. It was moot because Glanville canceled it due to the fact that he was in a review, he was in a procedure, or he was in a process of being recused, or they were reviewing or previewing or reviewing his recusal motions. So the actual show cause that he actually scheduled got canceled by him. So it was moot. She's saying it's denied. Wait a minute. Hold on. She's saying it is denied?
Oh, really?
Ew. Oh, that's nasty. That's nasty, right? That's nasty work right there. Hold on. Okay, number 3, defendant Jeffrey Williams, young thug, young slime, motion to disqualify, recuse Judge Glanville from all further dealings in the above reference case as amended and supplemented is granted. The clerk of court shall reassign this case using the court's case assignment procedures. It is so ordered this 15th day of July 2024. Okay. Very interesting. All right. This is very, very interesting because Caleb Bumpus's motion to quash is denied. Interesting. Very, very interesting. I'm curious to find out more information about that. Now, who is this? Who is going to take over the YSL case? Who is going to take over the YSL case? All right. Let's go ahead. Let's find out real quick who's going to take over the case. Okay, let me go ahead and share my screen again. Here we go. Kablowski. So this is Judge Shakira Ingram. Young Thug's case has been assigned to a new judge. This is her right here. This is her right here. Okay. Interesting stuff. Watch this. Interesting stuff. Let's read this real quick here. Who is this judge? Harpo, who this woman? Harpo. Harpo, who this woman? Honorable Shakira, I hope I'm saying her name correctly. Shakira L. Ingram is a judge for the Fulton County.
A bullshit. A bullshit. A bullshit. A bullshit.
You got to be kidding me. This is some.
A bullshit.
It's staying in Fulton County. The case is staying in Fulton County. Oh, this is so nasty right here. This is nasty work. Judge Ingram, who is the new judge. This is the new judge, guys. This is the new judge. This is the new judge, Shakira Ingram. What judge? Where's she a judge at? Fulton County Superior Court, 5th Judicial Administrative District. I think that's in the Atlanta Circuit in Georgia. She was appointed to the bench by former Governor Nathan Deal on July 9, 2018, to fill the vacancy created by the resignation of the Honorable Alford J. Dempsey Jr. Prior to her appointment, Ingram sat as a judge for the Fulton County Magistrate since 2015. She got a BA from Clark Atlanta University. She completed her JD at Georgia State University College of Law. Over the course of her legal career, she practiced as senior associate at Thomas Kennedy Sampson and Tompkins LLP, a senior assistant district attorney with the Fulton County District Attorney's Office. She worked for the DA and an assistant solicitor for the City Court of Atlanta. She used to work for the DA. She was a senior assistant district attorney with the Fulton County District Attorney's Office. Oh no, man. Come on, fam. Come on, fam. You gotta be kidding me. She was working at the DA. So she know all of them. Her memberships have included the Blackley End of Courts Master, the Atlanta Bar Association, Gate City Bar Association. She was past president, Georgia Association of Black Women Attorneys. Shout out to the Black Women Attorneys. Gate City Bar Foundation, past chair, and the Georgia Association for Women Attorneys. In addition, Ingram sat as a member of the state bar of Georgia's Committee on Professionalism. That's not a word that's normally used in Atlanta. That's not a word that's been normally used in Fulton County. The Atlanta Judicial Commission, the Atlanta Board of Ethics, board chair, and the Atlanta Bar Association's Women in the Profession section, past board member. Oh my goodness. From a civic standpoint, she was involved with the Delta Sigma Theta Sorority Inc., the Lynx, Buckhead, Cascade City chapters. It's My Birthday, Atlanta Incorporated. The Arthur Blank Family Youth YMCA. She was a past board member there. And the Enchanted Closet, past board member of that. She is a graduate of Leadership Atlanta. She has a husband named Marlon who reside in Atlanta. They got 2 of them children. Wow. So that is Judge Ingram. Yeah. Judge Ingram used to be in the DA office, cuz. Whoa, man. I did not read this. Again, I found this. I'm gonna be honest with you guys. I was at work and it was nothing really to do at this time because I completed all my stuff. So I was just looking up some stuff. And I came across some information about this, and I saw this recusal, the removal of Judge Glanville. So yo, this is wild, man. This is wild. Let me go to the comments real quick. This is wild. But let me know what you guys think here. You know what I'm saying? Let me know what you all think. Abundance said, I think all the judges in that county shouldn't handle the case as well. I totally agree. I totally agree, man. These judges are, again, this order of mendacity statement that Scott McAfee made about the hearing to remove Fonnie Willis from the Trump case. There's an order of mendacity in the entire circuit, yo. The entire circuit. Like, it went from one Fulton County judge to another one, you know, and they worked for the DA's office at one point. They were the senior. It says it right here again. Ingram also practiced as a senior associate at Thomas Kennedy Sampson and Tompkins LLP, a senior assistant district attorney with the Fulton County District Attorney's Office, and an assistant solicitor for the City Court of Atlanta. Yo, man, this is the judge that's going to listen. And look, this one thing I gotta say too. Don't let the smooth taste fool you. Don't let this face fool you, guys. Don't you dare, fellas. Don't let the smooth chocolate. Don't let that smooth chocolate fool you, dog. It might be a wolf up under there. It might be a wolf up under there. Don't you dare get caught up. Oh, don't you dare get caught up. Oh man, don't you dare. It might be a wolf up under there. I'm telling you. I hope she followed the law and not be biased. I hope so too, D Pill. I hope so too. Look at that. They're in the same circle. Man. Same circle. Says bond should be on the way. It should. It should. I think so. I think it should. I mean, why not? You know what I'm saying? Why not? Hey, it's so crazy because I came across a video about Glanville. he was in the news. They was investigating the cases that have not had any type of attention put on to them. And it's so crazy. I want to play all this real quick though. I mean, I've never seen this particular I never saw this particular interview that he did. But yo, when I saw this, I was like, man, we got to just look at this a little bit. We got to look at this a little bit, y'all. Give me 1 second, y'all. Because when I saw this, oh, Kayla Bumpus is live. I don't want to do her live like that. I don't want to do her like that. Hold on. Because I know she's going to talk about, we're going to do a video on it. Hold on, you guys. Everybody live. Everybody named Mama and them live right now. Oh, man, when I saw this video of Glanville, I'm telling you. Hold on, give me 1 second, y'all. So what do y'all think so far, man? They're in the same circle. Do you all think that this is, do you all think that she will at least not be biased? If you believe she will be, if you believe that she will not be biased, go ahead and put a 1 in the chat if she will not be biased. But if you think she will be biased, then go ahead and put a 2 in the chat if you think she will be biased. I want to play this a little bit. I want to play this just a little bit, y'all. Hold on, let me play this just a little bit. Yo, y'all rock with me for 1 second. Put Abundance said 2. My take said 2. You think so? You don't think she'll be you don't think she'll be fair? Hold on, y'all don't think she'll be fair? Y'all don't think she'll be fair? Hey, hey, matter of fact, let me put my 2 cents in. Y'all see that? 2. I gotta agree, man. You in the same circle, same circuit. I gotta agree. Yo. So that's what that is. That is the ruling. Glanville fired. He fired. Okay. That $2,000 donation tells me she won't. Yeah, there you go. Well, see, the $2,000 donation was towards Krause. Krause removed Glanville. So I don't know if Glanville ever donated to Miss Ingram, but he's definitely gave money to Rachel Krause. Now, this is an interview. This is an interview from Atlanta News, the first investigators, where he's asking Glanville about these unindicted cases. And this was not that long ago. This is only like last year sometime. Like this is still a ongoing situation right now. Okay. Now I know that there was an article that came out that talked about that 40% of the cases are now resolved as baloney. Watch this interview. I mean, I've never seen this, but this is Glanville talking about the cases that are unindicted and the indicted cases where people are not on trial. You got people that's not charged with anything in jail, y'all. In the Fulton County jail, they still sitting there right now. This is absolutely crazy. Everybody smash that like button for me real quick. Come on, y'all. Everybody smash that like button for me real quick, all right? Let's go ahead and look at this real quick, all right? And let's just see how Glanville responds to these cases that are not being resolved, these backlog of cases. Let's go.
Judge, thank you so much for doing this. I think your voice in this conversation is really important to add some clarity about why the jail is the way it is and how the court system has played a part into it. I'm going to throw out some numbers that I got from the county clerk's office, and I'd like to get your response to them if that's okay.
Sure.
As of August 21st of this year, according to the county clerk's office, there were 11,000 indicted defendants awaiting trial, 12,000 unindicted defendants awaiting to be indicted, and then a grand total of 23,000. That's about 5,000. That's about a 5,000 increase as of December. In your mind, what's causing this backlog in your mind?
Well, part of it is, from a trial perspective, is a unique aspect of the trial of criminal.
I'm sorry, don't he look like he just full of shit? I'm sorry, I tried not to cuss today. I really did. But he just looked like he gonna lie to you. He looks like the type of person that would just make up anything that sounds good to you, so that way it'll make him look good. Let's go, man.
Criminal cases. And what I mean by that is that 90 to 95% of all criminal cases will be resolved by a plea. And so if I can give you an example, when I call a 40-person trial calendar, about 20 to 25 of those people are going to enter pleas on some point in time on the continuum. Then you're going to have 5 folks that or thereabouts that have mental health challenges. So they either need an evaluation, they're pending an evaluation, or we need the results of the evaluations for the parties to be able to do something. Then you got about 5 folks that you can't do anything because of science. And then what I mean by that is because there's sexual assault kits or science that needs to be tested by other agencies. So their cases aren't in a position to be tried. And then you got 5 folks that are just going to say, I want a trial, and it's their constitutional right to go to trial. So if you look at the trial of a criminal case, a homicide, it takes 5 to 10 days to try those cases. And then on the average, a regular felony is going to take probably 3 to 5 days to try. So I can try 4 to 6 cases in a month's time. And so if you think about the other 2 categories of mental health and the science cases that are still outstanding testing, then coupled with the fact that I get new cases on top of that, I have to continually kind of touch those cases in order for them to be able to move. So that's part of the unique challenge of the trial of criminal cases. So and then you get new cases, and that adds to our current situation.
So the competency issue, the science, which it sounds like you're saying just lab results from GBI or
Yes.
the agency. What was the pleadings that take time? I was trying to go through the list of your reasons for. I want to make sure that.
The people end up taking pleas. Okay. I mean, and you're going to have 20 to 20. I'm just making a representative sample of 40 folks. So 20 to 25 are going to plead somewhere around or take a negotiated or non-negotiated plea sometime on the continuum, based on 90 to 95% of all criminal cases get resolved by plea. But then you've got science, then you've got the folks that have mental health concerns, and then you have people that want trial. So that's your last category. Okay. So those particular categories, and then I have to touch the people that have competency issues and follow up on those. And then I also have to.
I'm sorry, but he's full of it, because I'm gonna tell you something real quick. Most of those people don't want to take those plea deals, man. They don't. They get forced to. Those plea deals that they present to the defendants be trash. Trash. That's the reason why recently all the severed defendants of the YSL trial, that's why all of them refused to take the plea deal, because those plea deals be trash. They be trash. Trust me, I've been on probation before. I know what I'm talking about. Trash plea deals, okay? If you can't afford, and if you cannot afford a really good criminal defense attorney like Young Thug can, you best believe the plea deal is probably gonna be the best thing you can get. And that plea deal is trash. I'm telling you, plea deals be so trash. It makes you, it almost forces you to have to take it, because of the circumstances that it provides. It's terrible. It's against you. So what he's saying, that 20 people normally take plea deals, nah, most of them people are trying to refuse those plea deals.
Recalendar the people that are still outstanding lab results, because the prosecution makes decisions on whether or not to continue to prosecute that case. And if I'm a defense attorney, I have to be able to see whether or not that particular test result may provide my client with some type of defense. And we can't resolve those cases until those things are at least put to rest.
How does this impact the jail population, knowing all the factors that you just explained and how the backlog has increased? How does this impact the jail?
Okay, well, if you look at it, it's a collaborative, situation, but for all of us as justice partners. But if you look at the population of Fulton County is the biggest county in the state. We are the seat of government. We have almost 1 million people within Fulton County. We have 15 municipalities, including the city of Atlanta, which has nearly 500,000 people in and of itself. So we're a 365, 24/7 criminal justice entity. And then we've got a jail that was built in 1989 to house 1,100 people. That we have doubled the amount of folks in there just due to those factors I just.
Did you hear what he said? They have double the amount. It's built to house 1,100. Double that. So you got over 2,000 people in jail. And the conditions of Fulton County is abhorrent. It is ridiculous. And just because a person is in jail doesn't mean they're supposed to be treated like trash, man. Come on, now. People dying of bed bugs and all kind of craziness. It's ridiculous. It's ridiculous. You have doubled that number. You probably done tripled it now. Absolutely ridiculous.
Discuss. And then overcrowding is a national issue, Andy. We're not the only, I would say, county or city that has to deal with the issue of overcrowding. And then we got, if you overlay on top of that, the effects of COVID and the fact that those particular people that were arrested during that particular time period. And then, as I mentioned, the unindicted cases that you brought up. We as the court can't do anything until those particular cases are in fact indicted. And two of the factors we just discussed about, in particular, science outstanding, as well as the challenges with mental health defendants. Those are two things that Madam District Attorney Ms. Willis has to contend with to make a determination on whether or not to indict somebody and how to proceed and prosecute on those cases. So those two things really make a big difference on the ability for us to tackle those particular that particular jail population.
I found that the sheriff provided me some stats himself that I thought were very compelling. There were, as of August, there were 690 individuals booked in jail for at least 1 year or longer waiting for trial. 3 years or longer, 142 inmates, and Jesus. 19 waiting 5 years or longer. The DA says for those 19 waiting 5 years or longer, they were competency issues. They were in and out of mental health facilities trying to get them competent enough to go to trial. There was a gentleman I found waiting 13 years for trial. Again, he had competency issues. Should it take 5, 10, 13 years to determine whether someone's competent?
Oh my God, this is crazy. This is so
well, I tell you to begin with, I can't comment individually on any of those cases because of the requirements of the judicial canons of ethics. But what I can say that each particular case is unique and has its own set of circumstances and facts. And while it's not acceptable for people to spend those particular lengths of time in jail, our appellate courts review these particular types of cases on their individual basis to determine if that was appropriate. And this is something that we as justice partners are working very hard to identify cases that need some attention for various reasons. But as the things you just mentioned, mental health is a real big concern with.
He's a weasel. The appellate court, he's always talking about the appellate court. Why? Because that's the next step. Once the trial is over, it goes to the appellate court for review. And he banks on that. He do whatever he want to do during the trial. During the trial, he do whatever he want to do. And then what he does is say, well, it's going to go to the appellate court for review anyway, so I'm going to make my motion and do what I want to do right now. That is not how you withhold the integrity of the law that you all create. If they can create it, they can break it.
Because if you can't get somebody competent, you can't try them. And then there are limited issues as to what you can do with that particular accused in that particular case until those particular issues are resolved. So the prosecution has challenges with those types of matters, and so does the defense, and so does the court.
Yeah, my jaw dropped when I heard 13 years for that one individual. And I know you can't comment specifically on his case, but man, 13 years being in legal limbo, that's got to be really concerning to hear.
Yeah, I mean, it's one of those things you get on an individual basis. You have to kind of, without taking a look at the individual facts of that particular case. That's
whatever. I can't listen to him no more. Okay, we're gonna go to another video because I want to show you all a video that I came across of the conditions of Fulton County, and it's absolutely despicable, man. It's absolutely despicable. We about to get it in real quick. I got a little time today. I got a little time today. All right, let's go ahead and get this. Let's see here. Here we go. Give me 1 second, guys. Isn't what he's saying just a bunch of excuses? You think, why are you trying to bring forth some competency towards someone for 13 years, bro? 5 years. You're trying to get them competent enough for trial. When you're seeing results over and over that they don't meet the requirements for competency, so you try to force competency on them so you can jail them. You can jail them. That's it. What other reason is there? Absolutely ridiculous. Just take a look at this video here, man. These are the conditions, and this is, I mean, I know some of these videos got some dates on it, but they're still currently in these conditions. Just listen to this video real quick.
11 Alive, it is the cornerstone of the American justice system. The idea of innocent until proven guilty. But right now in Atlanta, many defendants waiting trial are held in that notorious jail known for decaying conditions and violence. Well, tonight, 11 Alive investigator Zach Merchant reveals hundreds of them are stuck there for months waiting for prosecutors to move their cases forward.
I want justice for my son because I won't never get him back no more.
The U.S. Department of Justice announced it's investigating conditions at the Fulton County Jail.
But I also had 4 knives pulled on me at once. I had knives put to my throat. He should have had his day in court. Instead, he had a funeral.
Story after story from inside the Fulton County jail system. To Reuben Gordon, they're no surprise. He spent almost 2 years there awaiting trial as an inmate.
Literally, they were going to sleep with one eye open because everybody had knives.
Like Gordon, the bulk of the system's inmates are housed at Rice Street, a building in such poor condition, its walls are crumbling, and inmates are using the pieces to make knives.
Everyone had some type of weapon that they made with the materials from Rice Street Jail.
Between January of 2022 and September of this year, 23 inmates died in the Fulton County jail system, according to records obtained from the sheriff's office. Most were treated as medical incidents, a few as violent crime scenes. Over a similar time period, documents record hundreds of stabbings.
This isn't a place anybody would want to spend time in.
Absolutely not.
But many are locked up there without formal charges. According to an October Fulton County government report, more than 1,000 inmates were behind bars still waiting to be indicted.
Unindicted.
Data presented by Commissioner Bob Ellis at a September meeting indicated more than 500 were waiting longer than 90 days. 60 have been waiting for over a year.
You can take a look too if you want to hang on to that.
We showed those stats to Atlanta-based defense attorney Robert Rubin.
It is tragic.
Rubin says an indictment is effectively the starting point of a criminal case. It marks the beginning of the formal march towards a trial. Without it, defendants in the Georgia legal system have few options.
So you can't get discovery before you're indicted. You can't file a speedy trial demand before you're indicted. You can't file other motions dismissing the case until you're indicted. You are in purgatory, essentially.
The Fulton County detention system is a jail, not a prison, meaning the vast majority of inmates have not yet been convicted of the crime they're held on. Those who remain inside its walls are typically there either because their bond has been denied or, like Gordon, they can't afford to pay it.
What were you charged with?
Burglary.
Eventually, Gordon managed to get out after his case was shifted to a pretrial diversion program. But many others remain unindicted and behind bars.
This is not acceptable.
Fulton County Commissioner Bob Ellis says multiple factors and departments have contributed to the case backlog. But he says a large part of the responsibility falls on Fulton County District Attorney Fonnie Willis's office.
You've got X number of cases unindicted. You've been handed significant amount of funds. You see what the numbers are. Do something about it.
Gordon doesn't need to be told.
We used to call Rice Street the Roach Motel, and you could check in, but you can't check out.
In Fulton County, Zach Merchant, 11 Alive News.
By the way, Reuben Gordon's case will be dropped once he completes his diversion program. This is according to the program's organizer. By the way, tonight he is still maintaining his innocence. 11 Alive.
That is the conditions, and that is Fulton County Jail, man. Knives getting pulled on them. Conditions all messed up. I mean, this is what they do, man. This is what they do. And all the money that was awarded and given to Fulton County was over $30 million. There was a $1.24 billion budget that Fulton County received this year. I mean, that Georgia received this year, or Atlanta did. And Fulton County, the county by itself, that county was awarded like $32 to $35 million, that range. And one of the things that was supposed to be a priority was the Fulton County Jail. As you can see, it has not been a priority. Now, they also had money to get special prosecutors. Teddy Oso, I appreciate you. Or is it Oso or Aso? I'm sorry if I mispronounced your last name. It says the DA office should dismiss the YSL case and save the taxpayers' money. That's a fact. That is a fact. You're wasting money. The money that they got was in the millions, and they were supposed to renovate the Fulton County Jail. They have not done that. They were supposed to, according to Fonnie Willis out of her own mouth, she said that she was trying to get money and she went to the board of commissions and all that kind of stuff because they're the ones that approve it, because the DA office has a level of latitude that most other constitutional positions don't have, according to the Georgia State Senate committee hearing. Y'all want to hear that real quick? The Georgia State hearing real quick? If you want to, put a 1 in the chat. If you got 25 more minutes, put a 1 in the chat. This is what they do. They have money. They have money. and they do nothing with it. Nothing that they're supposed to do with it. Fulton County's in shambles, man. Hold on, let me get to it real quick. This is absolutely crazy. Hold on. We're going to talk about this money real quick, because it's so much deeper than just recusing or removing Glanville from the seat. He should be removed, absolutely. But it's deeper than that. It's way deeper than that. They have money. They get money. Over $1 billion. Fulton County got over $30 million. They were supposed to renovate, to build up the Fulton County Jail so that way it could be somewhat livable in a sense. None of that happened. None of that happened. Hold on. Let's do this real quick. Let's play this real quick.
Should be aware that we have confidentiality rules on this committee. If there are any documents responsive to our subpoena that you feel like contain confidential information that should not be disclosed to the public, because we are creating a public record here, please identify those to me, and I will, in accordance with our rules, deem them confidential and shielded from public view.
Put a one in the chat that was too fast. Put a one in the chat that was too fast. I could follow it, but put a one in the chat if it was too fast for you all. If it was, I could slow it down to 1.25. This is about the money. This is about the finances that goes to Fulton County. Rob Pitts he's the man. Basically, he's the guy. And these people are his colleagues, and I'm telling you, man, this right here was crazy. No one saying anything, so I guess it's cool.
Just in conversations with your county attorney, I know Sue has told me there are certain things that she has redacted in these, if anything that dealt with the birth dates, social security numbers, health information of any of the employees of the county. And that is certainly fine. That's what we're trying to accomplish, to make sure that we are protecting documents that should be confidential, but also obtaining the records that we need to complete our investigation, and with the understanding that the vast majority of anything we ask for are in the public domain anyway. These are public government records that should be accessible to the general public, but also to the state Senate to conduct our work here. So thank you, and just let me know before we post anything on the website, any documents, if there are any that you feel like need to be shielded or protected in any way. Fair enough? Alrighty. Before we get started, I will need to swear each of you in. Mr. Pitts, I'll start with you. If you will raise your right hand, please, sir. Do you swear the testimony you will give before this committee this morning will be the truth, the whole truth, and to the best of your knowledge and ability?
I do.
And Ms. Whitmore, would you likewise? You swear the testimony you'll provide this morning will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
We have our court reporter present. We'll be making a transcript of all the testimony, and we're happy to share that with you. It will become part of the public record afterwards. If you later want to correct any answers or add information, we welcome that. And I will state before we begin, as we say every meeting, that our Senate website is set up that if anybody from the public has information you think might be relevant to our investigation, feel free to reach out to us and provide any information that could be relevant to us, and let us know if you would like to testify before this committee as our process unfolds throughout the summer and the fall. Mr. Pitts, let me get you just to give us a little brief background. You and I know each other, and I think most people in Fulton County know of you from your long history of public service. If you would tell us a little bit about the position you hold and how long you've been in the chairman's post and any other political service before that, I think it might give some context.
Thank you, Senator, Mr. Chairman. I've been, as you've indicated, been involved as an elected official for many years. I look at Senator Butler, and I kind of count sometimes to figure out just who's still standing. And I'm sorry that you're going to be leaving us. But I began my political career in Atlanta as a member of the Atlanta City Council. I served there for 20 years as a member of the Atlanta City Council. Then I was elected as president of the City Council. I served 4 years as president. Then I moved over to the county, where I served for, I think, 12 years as a member of the commission, as a commissioner. And for the last 7 or 8 years, I have been privileged to serve as chair of the Board of Commissioners of Fulton County.
All right. And in that position, how often does your commission meet? Is it twice a month?
We meet the first and third Wednesdays of every month.
Okay. Is it part of the duties and responsibilities of the Fulton County Commission to establish the budget for the district attorney's office and some supervision of that office?
We establish the budget for the district attorney as well as all other departments for final approval.
And when you're formulating the budgets, does the district attorney submit to you a budget request for public funding?
The process, and I'll defer to our chief financial officer, but there's a process where the department heads appear before the manager and the finance team to explain their requests, and then from there it comes to us for final approval. We might want to clarify.
So the budgets of all the county departments, including the district attorney's office, are ultimately approved by the county commission?
That's correct.
Okay. Ms. Whitmore, if it's okay with you, I may bounce back and forth between witnesses, because I understand, as the chairman just deferred to you, there are areas where you have particular expertise. Okay.
Yes, that's fine.
Brenda, I'm not going to make your life as miserable as you're sitting there thinking right now. Our court reporter is going to try to keep the transcript, but you will occasionally have to go back and forth between witnesses. I'm going to have Ms. Whitmore later direct line a question to her, but I may periodically let her chime in here. Okay. All right. Karen, tell us a little bit about that, how that budgeting process works.
Thank you, Mr. Chairman. Chairman Pitt's description is the general process. Actually, every department of county government, including constitutional officers and elected officials, submit an annual budget request through our budget development application. Those requests are reviewed, vetted, and verified through our budget office. The county's budget ordinance is designed in a way that the budget is developed and presented to the Board of Commissioners as a recommendation from the Office of the County Manager. So we have a review process that we undertake with the county manager and members of his executive team to review the requests that are presented. Typically, we provide each agency with a base budget figure to start with, and then they are allowed to submit what we call budget enhancements, where they can ask for additional resources to just continue an existing program, to expand an existing program, or to establish a new program or service. We also have a separate process that we run simultaneously as the operating budget for a capital budget requests, and there is a capital budget review committee that receives and vets all of those requests, and they are then in turn taken into consideration at the same time as operating budget requests, because we only have one pool of resources to use. So we consider all of those at the same time. So our constitutional officers and elected officials submit their requests through the same channels. Sometimes they may choose not to come and present to the county manager's office, and then choose instead to communicate their budget needs directly with the Board of Commissioners. So that, in a nutshell, is the county budget process.
And when you talk about capital expenditures, is that like new automobiles for police departments, new buildings, new expenditures on things along those other than personnel?
Yes, sir.
Good question.
Rolling stock, heavy equipment, facility renovation, new facilities, facility expansion, all of that would come through our capital portal process.
So when we talk about building a new county jail, that's a capital project.
That is one very significant capital project. Yes, sir.
Did you hear that? Did you hear that? County jail. That's one significant county project. Ain't that what she said? Isn't that what she said? Let's go, man.
Can you give us just a feel for what the size of Fulton County's annual budget is?
All funds included, it's about $1.2 billion.
$1.2 billion. $1.2 billion.
And do you have readily available what amount of general funds from the county are allocated to the district attorney's office on an annual basis? I guess we'll just talk about this year to start with.
In 2024, the district attorney's allocation was $36.6 million from the general fund.
$36.6 million from the general fund went to Fulton County. Fulton County got $36.6 million. Now, remember, she just said that you can allocate more funds. It's called a budget enhancement. You can ask for more money. You can ask for more money. All right. Remember this. Remember this real quick. Remember, I know, D Pill, I know, I'm telling you, yes. $1.2 billion budget, a general budget of $1.2 billion. Fulton County got $36.6 million of that, and they have the right and the latitude to add more money if they need to.
Chairman Pitts has tried to explain to me that there are several buckets of funds that are used to fund the district attorney's office. Would you kind of run that through for me as what additional funding over and above the $36.6 million of general funds from county tax revenues that are allocated to the district?
Yes, sir. The district attorney, in addition to the county's general fund resources, also has resources that are available through the confiscated asset forfeiture fund, as well as the victims witness assistance fund, federal asset forfeiture funds, and we keep all of these in separate funds, and then a number of different grants that come through the state and federal grant process. And then since really the middle of 2021, when we developed our spending program for the resources that we received through the American Rescue Act, the district attorney has also had resources available for what we call our Project Orca, which is our court backlog project that was funded out of our ARPA resources.
Okay, let me slow down on that one just a minute. Did you say Project Orca, like an orca whale?
Yes, sir. Okay.
Is that acronym, does that stand for something you could help tell us?
It's more I guess visual than that. It just was intended to mean that it was a very, an orca is a very large ocean mammal, and the court backlog that we had as a result of the slowdown in the court system during the pandemic was also very large. So the individual who was charged with developing a program to address the court backlog named it Project Orca, but it is our official court backlog reduction program.
And this is funded through federal funds?
Through our ARPA resources, yes, sir.
Okay, the backlog project. Do you hear what she just said? Backlog project. What did we just talk about with Glanville? The backlogs. What's the process? What is it that you need? You need lawyers. You need freaking lawyers, man. On the state level, you need both prosecutor lawyers and you need public defenders. You need lawyers. You're supposed to have a budget for that. You're supposed to have money for that. Instead, they put money into this YSL trial, and they have not given us any evidence, concrete, nothing concrete just yet. They have some speculative evidence, but nothing concrete. And the money that goes towards the backlog, where is it going? I know one thing. I know who got $700,000 of that $36 million. Your boy Nathan Wade got. Yeah, your boy Wade County got some of that money. You understand what I'm saying? Let's go.
And the ARPA money was put in to sort of help all the states recover from the COVID epidemic.
Yes, sir.
Okay. Do you know the amount of ARPA funds that were allocated to the district attorney's office or the ORCA project?
I don't have that number available with me today, but I can share it.
Of course you don't.
And as far as the expenditures of that fund, is that anything that the county commission had authority or discretion over where the money went, how it was spent?
Specifically, is your question specific to the ARPA resources themselves?
Yes.
Yes, sir. They determined where and how our ARPA resources would be utilized. The county executive team made a recommendation, and the Board of Commissioners adopted that recommendation, and we have modified it over the course of time as we have continued to execute on our spend for the ARPA resources.
And one of the areas you allocated some of the ARPA funding was to this ORCA project.
Yes, sir. In total, about $75 million is what we allocated to Project ORCA.
And who else was allocated funds through the ORCA project in addition to the district attorney's office?
Most of the partners from our justice system received funding out of the Project ORCA resources. The district
$75 million for the backlog project. $75 million. Oh, that makes me even more mad. Oh, wow. Okay.
Attorney's office, the state
sorry,
court, superior court, magistrate court, public defender, the sheriff's department. I believe juvenile court received some. So we took a look across the entire justice system to see where we would need to plug in some additional resources in order to develop a work plan to bring our backlog that had accumulated to bring those numbers down.
So if 75 million was applied to the ORCA project, do you know what amount of the 75 million went to the district attorney's office?
I don't have the exact dollar amount with me. I can tell you that she did receive funding to cover 75 positions, which was the highest number of positions that were provided across the justice agencies. But I'm sorry, I didn't bring that. I don't have that number with me. I don't know it off the top of my head.
You don't know the largest county in Atlanta. You don't know the number for that one right now, really? You're the chief financing officer of you don't know the number? Fulton County has 1 million people that live there. You don't know the number for that county? How much money, how much of that $75 million for the ORCA project went to Fulton County? I don't know right now. I just don't know. Really? You don't know? You should know. You should know like a motherfucker.
Certain if we even requested that. I know that you are continuing to compile for me the essentially the ledger or roster of employees employed by the district attorney's office, and I suppose we'll be able to break this out as you compile that data, right?
Yes, sir.
Okay. Do you have any idea how many employees in the district attorney's office now?
I believe she has about 277 employees, plus the positions in ORCA, so a little over 300, maybe 340.
And that would include assistant district attorneys and investigators and secretarial help, the entire spectrum of staff.
Yes, sir.
Will the ORCA funds expire anytime soon or be exhausted? I know if it came through ARPA, that's sort of winding down at this point, right?
Yes, sir. We are undertaking an effort currently to ramp down our ORCA spend within the $75 million that was allotted and within the general timeframe that was provided for the spending to occur, which is 12/31/2024.
So we're at the tail end of the last year of that, huh?
Yes, sir.
The way you described the budget process sounds very similar to the state budget process, where it's almost a continuation budget from the year before, and then there are requests for additions to increases if you need more staff or if circumstances have changed or need to make a capital expenditure.
Yes, sir. I mean, we tend to start from the previous year and build onto that. If a department received funding in a previous year that was not intended to be part of their recurring budget, then we make adjustments for that. That's why I said we provide them with the base budget. So that base budget each year will reflect the ins and the outs from, whatever transpired in the previous year's budget cycle. So if a department received funding for a particular project or purpose that's not intended to happen on an annual basis, then we pull those monies back out and readjust and realign their base budget.
Yeah. How much detail does the district attorney's office provide when they make their annual budget request? Is it fairly itemized by employee, by expenditure type, where it goes?
In our process, we provide them with a line item version of their budget in our budget development application. We provide them with a position summary. So we give them a report of all of their positions, and it's as of a point in time. And they are required to make any corrections to that position summary report, because that becomes the basis for their salary and fringe benefit budget for the base year. And then they are allowed to go in and align the operating portion of their budget in whatever manner suits their operational needs. We do have a couple of object codes that we really do not allow them to deviate much from, because they are necessary to fund things like our risk management fund. So, we have an object code specifically for that. That's a rate times the number of positions that you have. So there's no deviation there. But they do have the ability to go in and adjust their budget. They are requested to provide details, contract names and amounts for specific contracts. So like our Department of Real Estate and Asset Management would come in and identify their contractors that they have in their contracts that they have for things like janitorial services. If they have professional service contractors, they would identify them. It is an ask. Some departments do a better job of others than, providing a lot of detail and support for their asks. So, we spend a lot of time and a lot of back and forth trying to understand, especially when they have submitted for an enhancement request or a new program, trying to make sure that they've put everything in that they should be including in those requests. But they do have the opportunity to align it how they would like to see it and provide detailed explanations for their requests.
And,
wow.
Chairman Pitts, back to you just for a minute. That's why I was letting her get into the minutia there, because I know that's why you hired her, right?
That's correct.
Okay. The way you've explained it to me is that with certain elected officials that are provided for under the Georgia Constitution, like the district attorney's office and the sheriff's department, these are elected officials, and our state constitution provides the sort of parameters of their authority and responsibilities, right?
That's correct.
For those, particularly those two, a sheriff and a district attorney, do you micromanage their budget, or is it fairly well left within their authority under the state constitution?
Well, they're what we call constitutional officers.
My guy got some good questions, man.
Those, and then the district attorney is in a sort of a different category, but also now I'll have to defer to get the correct.
Well, excuse me, Pitts. What you mean different? What kind of category? What's so different about this category here?
Terminology from our county attorney, but constitutional officers believe that once their budget has been approved by the Board of Commissioners, then they are free to manage that budget any way they see fit. And that's because of this.
Did you hear that? Did you hear that? Any way they see fit to manage their own budget. Fonnie is managing however she want to manage it. She managing it.
Law, I suppose, that gives them that authority.
So you can't micromanage their spending once you've granted them the budget, appropriated the money to them from the general funds?
Probably not. And that's, I guess the answer to that would be no, we cannot.
But essentially, you don't have to appropriate money to them unless they can justify for you why they need it and what they intend to spend it for. The line item listing that Ms. Whitmore just referenced.
Right. When the departmental budget comes to us and say, even with the constitutional officers, they're line items, but we fund the line items and that results in a total. But once we've approved it, they can disregard the line items that we have approved, and therein lies, I guess, a source of conflict from time to time.
Do you have a good grasp on exactly how much money runs through the DA's office budget every year? 36.6 million comes from your general funds from the taxpayers of Fulton County. Mm-hmm. And they have money that they get from these forfeitures and from a portion of fine money. And then they may have grants, et cetera, both state and federal on top of that, correct?
Yes, sir.
And then the state itself funds a certain number of positions, including the district attorney's salary and a certain number of assistant district attorneys based on the number of judges in the circuit.
That's my understanding, yes, sir. But we do not monitor that. So why not? What?
You don't monitor the money that you giving people. Listen, people, did y'all hear this? This is the reason why you're seeing corruption. This is the reason why you're seeing the Fulton County corruption. This is why you're seeing the state corruption. They don't monitor anything. They don't even look after what's going on after they give them the money. They have a budget of $36.6 million. They also have the ability to have a budget enhancement, which is to ask for more money outside of the budget that they have. And they don't micromanage the money. They don't look at where the money goes. I would love to see the ledger of the state of Georgia and the Fulton County ledger. I would love to see it. I bet it's all kind of wrong. I bet it's all kind of crazy. Do you hear what this man said? We do not monitor the money that we approve. The board of commissioners approve the money. Come on, man.
What we are aware of is that the 36 plus million that comes from the general fund, and rarely do we keep up with how much they receive from grants or fines and forfeitures and things of that nature.
Right. That's something that's within the control of the district attorney's office.
Correct.
Yeah. Do they ever report that amount to you? I mean, it would seem in the course of making a budget request to you, they need to show a need for money, and that would necessarily require them to show you what they're getting from other sources to figure out what they need from you.
As a matter of course, that is not provided to us, and whether that is made available during the budget process for staff, I'm not sure.
We will look at other sources that they have available when they're asking for an enhancement to see if there is another source that could be used instead of the general funds. And I guess I would just like to perhaps add a little clarification to what the chairman just said about the other sources of funds. Those are maintained on the county's financial system. So we do have the federal asset forfeitures, the confiscated assets. There are buckets of those. They are presented to the board in the special appropriation grant funds. The board, there is no reporting that comes forward to the board on those. And because the board isn't authorizing those resources, they come from other sources. There isn't a lot that comes back to the board on those. From a grant perspective, like a federal grant perspective, we do present the grant applications that are made on our grant activity report to the board. And again, the grant activities and reporting are captured on the county's financial system and are included in our required single audit report each year. So that's the reporting, but there is no other reporting that is completed on those funds by the district attorney to the board of commissioners.
But from your accounting standpoint, you're the chief financial officer. When these funds from whatever source get deposited in a bank account, somebody's got to make an entry. The deposit was made and where it came from.
Yes, sir. So if resources are received, then they are presented over to the county treasury. They're deposited, and within these funds, then the spending credit, if you will, is provided to the agency that's receiving the funds. We have, multiple agencies that receive federal asset forfeiture funds and confiscated asset funds. So we track it by each department within those funds. And when the resources are received, they are given credit for them. On the grants, many of the grants are, of course, drawdown grants. So we're spending the county's resources first and seeking reimbursement from the granting agency. So whatever the required drawdown process is, our grants administration office in the finance department would be involved in assisting and facilitating the the financial reporting requirements. Programmatic reporting requirements are typically managed directly by the department or agency that has received the grant, but our grant administration unit will ensure that the whatever periodic required financial reporting is complete, and that the drawdowns are completed on a timely basis so that the county is not fronting that money for too long of a period of time.
And tell me what you just referenced, a single audit. What did you mean by that?
That's right. The audit that any entity that receives a federal grant is required to have completed on an annual basis. Our external auditors complete the single audit. It is a specific audit of all federal and state grant funds.
And is that broken out between your various county agencies and departments, including the district attorney's office?
Yes, the auditors have a requirement to identify major programs and audit on a risk basis. And so they determine which programs may get a more thorough and very specific audit process, but all of the grants are included, and all of the information that they ask for is provided to them as part of that single audit process.
Is that a written document report that you would receive every year?
The single audit?
Yes.
Yes.
Okay. And is that a requirement of each agency, including the district attorney's office, to provide the requested data and information to the auditor?
It is, yes.
By reviewing that, are you able to pretty well track all of the spending of grant funds anyway by the district attorney's office?
At a summary level. It's not detailed. It just basically gives you, the total amounts.
Of what was received and
expended.
what was
Yes, sir.
Does it give a category of the spending?
I believe that it's just listed by the individual grants.
Okay. Would that explain or reveal to you what personnel was paid for by specific grants?
It is not. The report itself is not at that level of detail.
All right.
No.
Is that provided to you in any way in your role as CFO? Do you get to see, which employees are funded by county money versus a federal grant versus a state grant versus a combination?
Yes, that information would be available to me.
I would hope
Again, when those grants are awarded and received, we establish the budget. If personnel expenses are included in the grant award, then the budget office will work with the recipient agency to ensure that the appropriate positions are created and established within the grant to ensure that they comply with whatever the application and the budget document that was presented to the granting agency includes.
And
okay, hold on one second, because we're about to go forward a little bit here, because this is where we get to squeeze some of the juice. This is where we get to squeeze a little bit of the juice. Give me 1 second. Let me come up some a little bit here. There we go, right here. Okay, back up some a little bit. All right, so we about to go. First of all, this is absolutely crazy. This is absolutely crazy. You giving people money, you're not monitoring the money. You're not even managing where it's going. You're just giving people money because they asked for it. Fonnie Willis was able to ask. She got a budget enhancement because she said she needed it to get more lawyers. She was supposed to get I think a total of 55 or something like that. Lawyers aren't like, that's what she said. But there was a position of lawyers for 70 something positions. Come on, man. And now, where are they at? Where are these lawyers at, man? You know what I'm saying? Let's finish this out real quick, because this right here, it got really interesting around this time in the interview and in the hearing. I'm telling you, man, this was wild, man. Wild.
Educate me. I'm wanting to, does that mean if Miss Willis hires 15 special prosecuting attorneys and pays them 10?
Let me go back some.
Would outside counsel have anything to do with criminal
Here we go.
prosecutions, or are they representing the county's interest in other type of matters?
Okay, outside counsel is normally called special prosecutors. Okay, special prosecutors. All right. So we talking about outside counsel. We talking about paying people outside of what someone that's special, someone that's on another level, if you will. Okay, this is what we're talking about right now. My man is like, is there a difference? What's going on with that? Right. So let's go.
You know, Joe.
She's the other person that's part of the finances.
Right answer. I thought I was right. I wanted to make sure we don't hire outside counsel for criminal matters.
Right, that would be for dealing with other county legal matters that you needed extra help from somebody other than the county attorney's office.
Primarily civil versus criminal.
So who's the brains back there behind you you're consulting with?
It's the county attorney.
What's her name?
Sue Joe.
Sue Joe.
Yes.
And that's SOO and then JO.
Yes,
I got that right.
Yes.
Okay. So Joe,
Come on up,
you to share some information with us. You're not under subpoena, and it won't be sworn testimony, but if it comes a time where you can help sort of enlighten us, you just let us know, or else you can keep letting the chairman know. All right. So those outside counsel have to be approved by the county commission. Correct. And it's done on the recommendation of the county attorney. Correct. Or the request, and that would specify the pay rate that those folks would be paid.
That's correct.
Right. And the second category.
Second category would be a special prosecutor.
There you go.
And
here we go. Nathan
special
Wade.
Prosecutor.
Big Wade in the building.
I believe I'm correct on this. That the district attorney has sole discretion
Big Wade in the building.
under very narrow circumstances, and I don't know how to define narrow circumstances, but that's how it's been described to me, to hire independent of the board of commissioners, special prosecutors. That's her decision and her choice.
But that
we have nothing to do with that.
You wouldn't have anything to do with the selection or approval.
Sam West.
That's correct.
Hey, shout out to Sam West with the Gene Deal thumbnail, man. Thug still getting found guilty. Hey, man, the judge is still in Fulton County, so you might be right. I ain't gonna lie, you might be right, bro. Who knows at this point? You might be right. Let's continue.
But you would ultimately be paying for that counsel through the general appropriations bucket in the budget that you approve for the DA's office.
Yeah. I'm told yes.
All right. And you're told that by your chief financial officer.
Yes.
That's her job to know.
Yes.
Okay. On those people,
we wouldn't know.
You wouldn't know the name of them
No.
or how much they're being paid.
No.
But you're going to see a line item on an audit at the end of the year showing how much that person was paid.
Correct.
You won't know who the special prosecutors are. You won't know. You won't even know their names. But they getting paid though. They getting that money. You see what I'm saying? They still getting that money, but you're not gonna know who they are. We wouldn't because of this budget enhancement concept. Crazy.
They're typically captured as professional services expenses.
And is that in a group or individual?
It's professional services object code within the district attorney's budget within the general fund.
All right, that's didn't educate me. I'm wanting to, does that mean if Ms. Willis hires 15 special prosecuting attorneys and pays them $10 million, that's all you see is that $10 million was spent for that type of personnel, or does it give you how much Mr. Wade got, how much Mr. Johnson and Mr.
So our system captures all of that, but as far as how our reports roll up, at the object code level, you would just see the total amount. You'd have to actually go into the accounting system and to extract the details of the payments for professional services, because there may be more than just legal services or outside or special prosecutor services within the object code for professional services.
If you've got professional services, it doesn't even delineate how much is attorneys and how much is a janitor.
Yes, sir.
Okay.
But why would you just do you got an account that says professional services? Okay, think about this on a ledger level. You have an account that says professional services. Okay, the word professional is referring to a person. You don't put the people's name in that account on your ledger. What you do is just give a total amount of money that just says professional services. Okay, what did they do? This is an audit, ma'am. This is an audit. You're a chief financing officer for an entire state, county, everything. You are in charge of the budget. It's $1.2 billion. Where is the money going? You got to do an audit. Means every red cent has to be accounted for. Where is the audit information of the professional services account in the ledger? Who are the professionals and what are they servicing? This is common sense.
So if I want to find out how much Mr. Wade was paid for his services as a special prosecutor, who has that data? I want to issue a subpoena to find that out. Do I give it to you as the county and you can discern that, or do I have to go to whoever hired this professional service provider?
The county actually has an open government platform. You could go to our open checkbook and you could search by the name, and it would pull up the name of any vendor that matches that description, and you could find payments that way. So you could go in and type in Mr. Wade's name or the name of his law firm, and you would be able to pull those documents. You could also submit open records requests to the finance department, and the accounts payable team would pull the details and provide that documentation, or you could subpoena probably the district attorney or any member of her staff that is involved in their internal accounting and vendor payment process. It was included in my subpoena.
So that's my question. Yes. Can you find that information?
Yes.
Or do I have to go to the DA who may not provide it?
No, we have that information.
Okay. So you can tell me the recipient by name.
He may not provide
professional services payments.
What we provided today was specific to Mr. Wade. We are working on the request. Also included any other attorney, so we are still working on that. Our process is we are searching now through all of the transactions within that professional services object code, pulling out the ones that appear to be legal firms and pulling the underlying supporting documentation to determine if they were in fact legal firms and if those expenses are responsive to the subpoena, and if so, they will be provided.
And I know I might sound a little lawyerish here. I don't mean to be hounding you, but I'm wanting to make sure that I address that subpoena to the right person. And I'm told you are the bomb. You are the answer to financial questions in Fulton County. Where you can get them. If I'm wrong, help direct me where I need to submit additional subpoenas to track down that information?
No, sir. Submitting a subpoena to me is should be sufficient.
And I will say on the record, you have been very responsive, and I know it's a lot of data and information, and I appreciate your efforts to continue providing that to me.
Thank you.
You have been completely transparent and helpful in trying to find things. So you said supporting documentation. What kind of supporting documentation would there be for a professional services payment to a law firm?
Typically, the billing statement.
Do you have supporting documentation to show you a contract with them, with the independent contractor between the legal services provider and the district attorney's office or the county?
The contracts typically are not provided as part of the supporting documentation. It can be requested. But
from you or from the DA's office?
If I have it, I will provide it. If I don't have it and it's something that I can't get, then I wouldn't be able to provide it.
Okay. Because this is sounding to me kind of like the Wild West. Very little control from Fulton County over a $36 million budget. You don't know how much of that is spent on professional services.
Right.
Who's hired, how much they're paid per.
He said you can just do whatever. You just do whatever you want to do, and that's fine. No matter how much of the amount of money it is, you can do whatever you want. And no one accounts for it. That's crazy. If you give your children money that they ask for a specific thing for school, like their graduation gown, right? And you give them however much money that costs. Instead of them getting the gown, they take it to do something else and tell you that they got the gown, but never show you evidence of the gown, never show you anything about the gown at all. And then you find out that, oh, you spent that money somewhere else. And it's like, now it's like, okay, why didn't I go after and make sure that I got the gown for them? That's basically what he's saying. It sounds like we need to do this for you. We're not supposed to do this for you because we're supposed to trust you. But we need to do this for you now because you're not responsible or capable enough to do this on your own. That's why we subpoenaed your ass. You can just do whatever. And then Nathan Wade got $700,000 to put some foots in the fanny, in that fanny. God, no, $700,000 for the cookie, for the schlong, man. That's money
per hour, what their total compensation is. Yet you're being asked to provide $36.6 million a year that you know encompasses a number of those type of independent contractors that
tried to trust you. I got a question,
control, right?
That's all this is. That's all this is right here.
Commissioners has no oversight over the district attorney.
So your only control is the power of the purse. Whether you continue funding money that can be used for those purposes, or whether you restrict that funding. Is that fair, Chairman Pitts? I guess that's really your question.
Could you repeat that, Mr. Chairman?
So your only control is the power of the purse, is either granting or rejecting requests for additional funding from the DA's office.
That's correct.
Okay. And that has to be based upon assurances presented to you by the DA as to why she would need particular amounts of funding.
Right. The DA can come before the board and make a request at any time, and we would consider the request, and if we agree, then we'll grant it. Right. If we disagree, then we won't grant it.
And in that request, do you require her to give some specifics? You know, some who I want to hire, why I need to hire somebody, how much I want to pay them, what's going to be the cap on their.
We don't get into that sort of detail. I mean, she'll make would make.
Why not? What the
case as to why the need is there and what it would cost. But as far as individual names and what the compensation for a given individual would be, and we don't get that kind of detail, nor do we ask it.
Did DA Willis ever make a request for specific funding for a special assistant DA, prosecuting DA for these for Mr. Wade?
Not to my knowledge.
And is her position that she doesn't have to ask or provide that information to the county in order to make a supplemental funding request?
Well, again, with respect to the special prosecutor, that's solely the purview of the district attorney, unlike the outside counsel.
All right. But you fund the district attorney based upon her stated needs or her request for funding, right?
Correct.
Okay. In her budget request, does she have a category for special prosecutors?
I don't recall saying a special category.
He put a little Woody. He did a little Woody. I don't recall. He did a Lil Woody. I don't recall. Hey, everybody put Lil Woody in the chat, dog.
Mr. Chairman, I guess I would have to say that she, as have prior district attorneys, have asked for resources, trial expense resources, without it being specific to X amount for a special prosecutor or X amount for expert witnesses or things like that. I think that it's been more like we know we have these major prosecutorial matters that will be moving forward and will require additional resources, but I don't recall there being any specific line item details necessarily associated with that.
All right, so we heard testimony at a previous meeting that there was a team of at least 10 assistant DAs working on an election interference case, and at least 3 special counsel that are being paid as independent contractors, including Mr. Wade. Was that ever described to the county commission in any of the funding requests?
I don't recall that coming before the board.
So she never came to you and said, I'm going to need a lot of money here to conduct this prosecution of, now there's 16 different defendants on, I'm going to call it the election interference case. Was that ever expressed to the county commission that that's part of why you were asked to give 36.6 million?
Again, not with that level of detail. So again, trial expenses.
Just generically, not even for the type of prosecution.
I want to say for the 23 budget, and I will have to go back and verify this, that there was some communication where she identified a need for resources because she expected to have to have to retry a case that had been a high profile case, as well as the gang matters that she has. I think there are a couple of those, and the elections, the elections interference matter as well. But again,
Rico?
It was a lump sum, not specific with line item details.
So you think that was in her budget request, perhaps in 23? Are we talking about Young Thug trial that's been going on forever and ever so far, or different gang related?
I believe there.
The Young Thug trial is going on forever and ever, dog. You talking about that Young Thug trial? You trying to say street? You trying to use the word street to replace Rico?
There is more than one gang-related, large-scale prosecutorial.
I'm having too much
fun. Yes, sir, that would be
bro.
one of them.
And you think she may have also itemized the election interference case would require additional funds, or categorize that as an area of needed funding?
Yes, sir. Again, I would have to go back and look. Well, I don't, because
You don't have to go back anymore. You got your right-hand woman right there to help you.
So
there you go.
Yes, sir. That was Sabrina McTier, the county's budget manager. So this is from the 23 budget enhancement request, and the description says, and I'll just read it, the general rule, the more complicated a case, the more likely expert witnesses, e.g. professional services, are needed. That was in parentheses. State versus Tex MacGyver has been remanded to this office. This case alone cost $675,000 in professional services. I have this case and several anti-corruption cases that are being litigated in 23. It is sufficient to enhance this budget, and the request was $1.1 million.
So that was for Tex MacGyver and any other public corruption case.
Yes, sir. So that's the kind of description that I was perhaps not doing a very good job of,
You're
expressing. But
you're doing great. And as far as
Wow,
my recollection,
man.
Chairman Pitts, is that she never named that she would need a special prosecutor on any election interference case.
Not that I recall, sir.
Certainly never told you the names of who she might be hiring or how much she was going to have to pay them.
Not that I recall, sir.
Did she make other
He don't recall.
budget enhancement requests?
But I don't recall in the chat, man.
21 or 22. I can't remember exactly when she was.
But I don't recall in the chat.
Madam DA was sworn in and began her term in 2021. So we did receive enhancement requests from her for the 22 budget cycle, the 23 and the 24.
What was the $5 million enhancement request for clearing up homicide backlogs? Do y'all recall that? That was testified to your last meeting.
That was a request that came through in the middle of 2021. She requested additional staff to support a number of items, the outstanding homicide situation being one of them. Ultimately, in 2021, through a budget amendment process that we call budget soundings, the Board of Commissioners did authorize her to have funding for an additional 55 positions. It was a mix of attorneys, investigators, and administrative support personnel. And in 21, the cost that was necessary to begin to onboard those positions, because she would not be able to do all 55 at one time, was less than 800,000. I think the budget soundings was 780,000 and some change. But the full annual cost for that is the $5 million. And so we built that in then to her 2022 budget with the full year funding for all of the positions that the board awarded her mid-year in 2021.
And was there any mention in that $5 million enhancement request that would be needed for any type of public corruption investigation?
I'll have to go back to the source document to confirm that.
What do you call that source document? Because I'm going to want to make sure I have adequately identified what I need to be produced.
I would call it a budget soundings request.
Okay. And can you provide those to me without me submitting an additional subpoena? I think they're included in what I've asked for. Just, I may not have been as specific because I didn't know what to call it.
Yes, sir. I had intended to include the 2021 soundings information as part of the request for the budget information that was already included.
You can just follow up and get that to me or Secretary Cook at your convenience. And if you would do that for any of those sounding requests for 21, 22, 23, and 24, just to keep me up to speed. Because Chairman Pitts, what
this is crazy, man.
am hearing from you is that the Board of Commissioners never got any kind of specific request for additional funding to prosecute any election interference cases, other than that generic 1 million,
Yo, each case, a high profile case like Donald Trump stealing an election, it's going to cost more money for that case than any other case ever. It's going to cost more money. YSL trial, a high profile case, it's going to cost money. You don't have specific budgets for high profile cases?
in 23.
Not that I recall, sir.
And no specific information about who needed to be hired as an independent contractor or what they would cost. I understand Governor Barnes was too expensive, and I just didn't know if that's that y'all figured that out or she ruled him out for that reason.
No, not that I recall.
I am subject to hiring a man.
Right.
Hey, man, Rob,
gun for hire.
You got Little Woody. I don't recall.
Pleasure to have you in the audience with us today, Governor Barnes. And I'm just wanting us to get a feel and for exactly how much oversight there is. It sounds like it's very loose as far as practices and expenditures for independent contractors.
Yeah, that information doesn't come before the board.
Right. Only you have to peel it out in these soundings and in the annual audit and in the budget submissions as she gives you the categories of what she needs.
That's correct. And when budget soundings come before the board, there's a little more detail and more specifics.
Right. Probably pretty difficult politically for you and the Board of Commissioners to reject a request for needed funding to clear up a backlog in homicide cases, right?
Well, I mean, we had such a tremendous number of cases that were so-called, they've been there for up in the thousands. And we decided that the 75 million from the ARPA funds has already been referenced by Ms. Whitmore. Right. So in order to we threw 75 million of I think we received a total federal allocation of about 206 million in ARPA funds, and 75 million of that 206 million went to the justice system. Right. And the justice system, meaning everything that the CFO has outlined.
So that was back in the fall of 2021. It was about the same time Mr. Wade was being hired. And it wasn't mentioned to you that any of the enhanced money was going to go towards Mr. Wade or any other special prosecutor to prosecute election interference.
I don't recall.
No, it was my understanding that 75 million was to be used for the justice system, and specifically, to reduce the tremendous backlog that we had.
And there was a $5 million enhancement that was from county funds, not the ORCA funds, or is that the same money?
Is that the same money?
No. The $5 million is general fund.
Okay.
County.
And in that request, that was on top of the ORCA funds to get rid of the backlog of homicide cases.
Damn.
Yes, sir. She actually asked for over 100 positions. When she made the request, and the way in which we addressed it was we already had the backlog program in development, and so we identified a certain number that would be funded through the backlog project out of the ARPA resources, and the balance we provided for out of the county's general fund.
And this is back in the fall of 2021.
Yes, sir.
2 years before her 1.1 million request for public corruption and tax MacGyver.
Yes, sir.
Did she ever report back to you the progress being made? What kind of bang you were getting for your buck? You're giving her $10 million in either ORCA funds or federal and state county general funds to get rid of this backlog. Did she do it?
I don't recall any specific report back to the board from the district attorney.
Shout out to Rob Pitts, dog. He hit him with the I don't recall joint, bro. He hit him with the I don't recall, bro.
However, I don't recall any specific report back to the board from the district attorney. However,
I don't recall,
at each
man.
meeting of the board, we would receive an update on the progress that was being made. That's accurate. Isn't it?
Yes.
Oh my God.
Yes, sir. As part of our global pandemic response, we presented the Board of Commissioners with an update for a while at every board meeting, and then eventually at just one meeting a month to update them on our progress using our ARPA resources, and specifically on the backlog project, showing total backlog cases, progression of those cases through the system. And so we've been reporting on that regularly up until February of this year due to our cyber incident. So we are almost ready to begin that reporting process. Again, the last report that we made on the progress of Project Orca was in January at the second meeting of the Board of Commissioners in January, and that was for progress through the end of 2023.
So would that list the number of homicide cases that are pending and how many are being resolved on a monthly basis?
It doesn't list case type. It lists the total number of projects, the total number of cases by each of the players, if you will, the solicitor, the magistrate court, the district attorney, and then superior court and state court. So we kind of track the progress of the cases from the two prosecutors, from the solicitor and the district attorney, into their respective courts, and then we track the progress that the courts themselves are making in fully adjudicating the cases. So that information is all presented to the board in a chart and discussion, and what's happening, all the various different things that we had to do in order to see that line make the progression that we were looking for.
So how many backlog cases were there? Do you have a ballpark figure how bad this got back in 2021? We're a year into the pandemic.
Here we go.
Are not trying cases. Oh, wow. You got a cool color report there. Is that my notebook?
We'll get an exact number. It was
how many?
We started, our drop date that we used to define our backlog cases was December 6, 2021. And we started with a total of 148,209 open and active cases.
148,000 backlog cases? Are you insane? I know I did not just hear that. Did y'all hear the same thing I heard? I mean, seriously. Did y'all just hear what I just heard?
And we started with a total of 148,209 open and active cases.
148,209 active backlog cases. Are you outside of your mind? Are you outside of your mind?
There. Is that my notebook?
We'll get an exact number. It was.
We started our drop date that we used to define our backlog cases was December 6, 2021, and we started with a total of 148,209 open and active cases in any stage.
That included the solicitor's office
Yes,
that prosecutes
yes.
misdemeanors.
Across the
and
justice
DA's
system.
office that prosecutes the felony offenses.
Yes, sir.
Just break them out. How many are state court versus superior court?
The state court the starting point for the state court was 20,124.
So the vast majority of them, or at least 2/3 of them. What's the superior court?
Superior court was 15,888.
15,888 superior court cases that were backlogged, and out of those backlog cases, you had some people that was unindicted, which means not charged. You were not charged. Come on, man.
Then you got magistrate courts as well, I guess.
Magistrate court was 39,430.
Magistrate 39,000.
From a speeding ticket to parking ticket, very minor.
Variety of yes, sir.
What else you got? Municipal court, I guess.
The solicitor general had 56,462 at the starting point, and the district attorney had 16,300.
Okay. Where's the 16.3 now, or at the end of 2023? Has the DA used all these millions to any good to catch up?
From our report in January, the district attorney's number was 130 cases that were the original ORCA. So this is only tracking the cases that were considered in the ORCA backlog that started at 148. So again, these resources were only supposed to be focused on reducing those cases. There were still new cases, of course, that come into the system since that point in time. Right. And this report does not talk about those. This is specifically focused on those ORCA cases.
Those new ones are not funded through the ORCA funding.
Correct. Okay. Correct.
Makes sense.
For who?
Start for the DA, you started at 16,300 and ended up with 130.
Yes, sir.
Okay, and that was from
December 6th of 2021 through 12/31/2023.
And we can't discern whether they're dismissed cases, whether they're plea bargain cases, or
Right.
trials to a verdict.
Not from this report, no, sir.
Dude, I love this dude. His questions are so on point. Listen to what he's saying. He's unpacking this. Listen to what he's asking. Okay, I want us to listen to what he's asking, because you're telling us that you had 16,000, whatever amount of cases you had, and it dropped down to 140. But how? How did it drop down? Were they plea deals? Were they trials? Were they like? How was this actually broken down? Listen to this real quick now. I mean, this is really, really important.
21 through 12/31/2023.
And we can't discern whether they're dismissed cases, whether they're plea bargain cases, or trials to a verdict.
Not from this report, no, sir.
They just got out of the system, resolved one way or another.
So for the district attorney, they were either moved on to Superior Court, which is where her cases would typically go, which means she still has to then prosecute them. But what we were tracking is, the cases that she had were, they were still sitting in, per se, in her queue, if you will. Yeah. So from 16.3 down to 130, they either moved on into the further into the prosecutorial process, or yes, they were dismissed, or whatever the other term is that you would use when.
This makes no sense. This makes no sense to me. You had 16,000 some odd, dude. He's checking on her faking the record. Yeah, but exactly. Listen, you had 16,000 plus cases. Now you dropped it down to 140 something, right? And you're talking about those cases moved on to Superior Court, which is a trial case or trial cases. You just said you only had about 300 something lawyers in Fulton County that was active from the state. How are you able to try at least 10,000 of those cases with 300 something lawyers? It's bullshit. I'm not going to try. I'm trying not to cuss, man. I'm trying to learn not to cuss all the time, but it's bullshit. It's literally.
A bullshit.
A court case doesn't progress when a matter doesn't progress.
Did your reporting requirements for these ORCA funds require any detail as to the successful completion of a case, whether there was a conviction or a plea, or they just dismissed it, or did they break it down for you that way? Or just one lump sum number of these cases are resolved, they're no longer in our system, in our queue?
We did not.
Great questions, bro.
Require that level of reporting to the Board of Commissioners. We do have, I believe, that level of reporting from our criminal justice system, but it's just not included in what we reported to the board.
And does that criminal justice system of Fulton County prepare a report giving those annual updates or dispositions of cases?
They have not. This is something that the executive team.
They don't even present. They don't even present reports.
That was established. That like the chief judge of Superior Court, chief judge of State Court, magistrate court, chief judge, the clerk of Superior Magistrate Court. They all participated in the steering committee process. Our former COO, Alton Adams, guided them through that process. So there was no explicit reporting requirement for that detailed level of information made by the board to the group, but the board did want to see, the results of their efforts. So, Mr. Alton worked with the judicial partners in developing the information that was reported back to the Board of Commissioners.
So you think that criminal coordinating council, or whatever they're called, kept data that specific as to the outcomes of the cases?
I think it's in our system and can be pulled out. I don't know. I didn't participate in those sessions, so I don't really know what they did with that information.
Yeah, don't put me in it. Don't put me in it, dog.
Perhaps Mr. Adams, Alton
He's
Adams.
No longer COO.
He is semi-retired. He is continuing to work with the county as a fee-based employee to help us move further down the road with the potential.
It's beyond sad, bro.
Mr. Adams, a fee-based employee. Does that mean he's still working just on an hourly basis?
Yes,
or
sir.
Kind of a consulting type thing?
Project more specific to the project, the replacement jail project.
Okay, so that's the project.
Jail replacement project.
Yes, sir.
Okay, thanks. All right. This might be a nice time for a little break. Would you guys appreciate or need a little bathroom break, a little stretch your legs type thing? We're going to recess for about 10, maybe 15 minutes here, and then I'll try to start wrapping some things up. I appreciate. I know it's a broad range of questions, but you're helping educate our committee. Thank you so much. Everybody.
Did he? I can't remember.
The disposition of the cases was, but we might be able to find that out through this other council. You got to tell me the name of it again. The judicial court system. What was it called?
It was the steering committee for Project Orca.
And they would probably be able to give me a more thorough explanation of what happened to those cases.
Boom.
Yes, sir.
So basically, was the DA's office good stewards of the funds that you allocated to them to accomplish the purposes that you gave that money for? Is that fair enough to say? We're trying to monitor that somehow?
Through the reporting, yes, sir.
Okay. You can leave that microphone instead of having back and forth if you want to.
Let's have it.
Okay. So, Mr. Pitts, I'm summarizing briefly, but it sounds like the DA has pretty wide discretion how they spend the money that you appropriate to them.
Here we go. The DA has wide discretion.
And does not have to basically get any type of pre-approval for hiring independent special counsel to assist in the activities of the DA's office.
That's correct.
Okay. And doesn't have to even report back to you how the money was spent or who was hired as an independent contractor and how much they were paid.
That's correct.
Okay. Did the previous DA seek prior approval or use this mechanism of special prosecutors?
Did he? I can't remember.
He don't recall.
I don't recall.
The man don't recall, man.
Paul Howard was DA for what, 20 years or so, right?
Quite a while.
Yeah.
20 years.
Special prosecutor. He could have. I just don't recall. You?
No, I don't recall. I would have to research that.
Would you take a look at that? Because I haven't uncovered any
Everybody
use
put
of
Lil Woody in the chat. I
special
don't recall.
assistant district attorneys by the prior district attorney who was in office for a couple of decades.
Yeah, I believe that request number 12 at least would cover 4 years of Mr. Howard's tenure, and it's for outside counsel by the office of the district attorney from 2016 to 2020. So I think that would cover that item.
You'll be able to ascertain whether he had ever even utilized this device or this mechanism to sort of bolster his manpower in the DA's office
During that period of time, yes, sir.
And I didn't want to be overly burdensome and ask you to go beyond 4 years back, because I think that would capture the contrast between the two administrations. Okay. So, Mr. Chairman, are you satisfied with the transparency and the disclosures, or the kind of keeping you in the loop by the DA's office on her use of special prosecutors?
Well, I mean, we've never had this situation before. I just don't recall under her predecessor, Mr. Howard, using a special prosecutor. So this is sort of new territory. Now with outside counsel, that's different because that is recommended by the county attorney.
On behalf of the county?
Yes.
In civil matters?
Yes.
Okay. But you don't have a recollection in all your years of service of previous DAs ever utilizing a special assistant district attorney?
Not that I recall, no, sir.
If they did, it was never brought to your attention or disclosed or publicized so that you would know about it?
That's correct.
And I think your position is that as a board, it's been communicated to you by the DA's office that she does not need your prior approval of such contracts.
But let me make sure I understand that.
The DA doesn't feel like she needs the prior approval of the county commission to hire independent contractors.
Well, technically and legally, she does not with respect to special prosecutors under these very, as I understand, very narrow circumstances. And I'm not sure how that's defined.
Well, let me.
So Nathan Wade was hired under her own discretion without having to report his salary, without having to report what he was hired for, or the details of it, nothing. At her discretion, she was just able to do whatever she wanted to do.
Help you with that, because this process is set forth in the official code of Georgia, annotated title 15-18-20.
Okay.
And I'll just read it into the record here. Under subparagraph A, the district attorney in each judicial circuit may employ such additional assistant district attorneys, deputy district attorneys, or other attorneys, investigators, paraprofessionals, clerical assistants, victim and witness assistance personnel, and other employees or independent contractors, as may be provided for by local law,
man.
Or as may be authorized by the governing authority of the county or counties comprising the judicial circuit. Now, Fulton County is a single county judicial circuit, right?
Yes, sir.
Okay. And so you are the governing authority as the board of commissioners of that county.
Yes, sir.
Okay. And what you're saying is that you have never authorized her hiring independent contractors to assist in the prosecution of her duties.
That's correct. It wasn't required.
Well, this law requires it, but the county did not require it?
Well, the distinction again that I make is a distinction between outside counsel and the special prosecutor. It was always my understanding that the district attorney had the authority to hire a special prosecutor as he or she saw the need to do so.
And that's the position that Ms. Willis has stated to you as chairman of the commission, that she was not required to get prior approval or authority to hire Mr. Wade or anybody else for that matter.
Well, I didn't have a direct conversation with her about that, but that's just the way it is, and the way our understanding was that because it's a special prosecutor, it did not have to come before the board for approval. And I was asked that question quite a bit by the members of the media. Said, did this have to come before the board? And in researching it, we concluded that it did not.
Right. I'm going to ask your county attorney to help me with that research, because she and I have had conversations about any court interpretations of this statute as we flesh that out. As the commission chairman, would it be your preference that DA or other constitutional officers should seek your approval before hiring independent contractors that you are responsible for paying for?
Yeah, that's a different. Repeat that. Let me make sure I understand you, sir.
As the county commission chairman, yes, would it be your preference that the district attorney did have to seek your approval before going out and hiring special prosecutors or independent contractors? If you're paying for it, or your general fund is.
Well, but under the, the current law, as I understand the current law, as it relates to constitutional officers and this, and the district attorney does not fall under that like the sheriff and the others do, but sort of. And she's sort of a state constitutional officer, as I understand it.
So
a little different.
Part of the job of this committee is to determine whether we need to change the law. If it's unclear in this case, and I'm wondering if you were the lawmaker here, would you like to see state law changed so that a district attorney would have to ask your prior approval before going out and entering into contracts with special prosecutors?
Well, probably my opinion may be a little different because I focus on the money, and I'm always want to follow the money. I'm a fiscal conservative and like to know how the money is being spent. But with respect to a district attorney hiring who she or he or she believes that they need to, I don't have any issue with that. But I would like to know how the money is being spent.
So we're back to the keeping you informed and the transparency of this process. If a DA is allowed to unilaterally hire whomever they want to at whatever price they want to pay them, do you feel like the county government ought to be able to be kept in the loop on this and reported to as to how your money was spent?
Well, in the loop, yes, there's no doubt about that.
Okay. And you don't feel like this process has been transparent so far?
Well, to the extent that we were not advised of the hiring of and not that it was required, of a special prosecutor, nor the payment, hourly rate or whatever the rate was. We were just following the law, and obviously I'd like to have more information. But that was the law at the time. It is the law at the time. I understand the law.
It's cool.
In your opinion, has DA Willis been forthcoming or transparent with you and the commission as to her utilization of special assistant district attorney in this election integrity case?
Well, to the extent that this is all new ground for us and for all of us, and
that's because it wasn't utilized by the prior district attorney for the last 20 years before her election.
Well, this whole issue with the election integrity, election interference, and all of that, it's new territory for us, and we're sort of, feeling our way.
We're answering this,
even with the trying to work down the backlog of cases that we had. So
we were
sort of making up rules as we went along, to be honest with you.
Sure. Do you worry that she was utilizing resources for prosecuting an election integrity case rather than getting rid of this backlog of 40,000 criminal cases?
Would you repeat that?
Does it worry you that she was spending significant resources without prior approval or even any reporting or accountability pursuing an election integrity case rather than working on this backlog of 40,000 criminal cases that were pending in Fulton County? It might have been 56,000. I can't remember all my numbers. It was a lot total.
Well, as I said earlier, and as the CFO said earlier, we appropriated 75 million of the 206 million of the ARPA money that we received to the justice system. And she had, in addition to the backlogs, she is currently involved with the YSL case and the election interference case. So those were, three really unusual cases that I had never experienced before. So we were trying to be as helpful to her as we can and could by providing, for the most part, the resources that she asked. But as far as what happened to the resources, the money, when I say resources, I mean the money that we gave her, we, after it was given to her, we tracked the cases, the backlogs, and we'll the jury is still out on the YSL and the election interference. So it'll all come out in the wash, I suppose, as to how effective it's all been. But we provided what was asked for, and we've not asked for, nor have we been provided any interim reports as to how we're proceeding, other than with the backlogs.
So she hadn't really told you how she spent the money?
No, sir.
And so you gave her 75 million plus at least another.
Well, it wasn't just to her. That was the whole justice system at 75 million. Right?
That's
yeah,
correct.
It wasn't just to her.
All right. You gave her many millions of dollars to get caught up on a backlog of criminal prosecutions.
Yes.
Okay. And when you did that, there was no mention of any election integrity case, was there? That didn't really ever come up specifically. Just this one sounding for additional money in 2023.
I believe that's correct. When you say that's correct.
Yeah.
The 1.1 million for Tex MacGyver and public corruption is the only thing that could specifically have reference to an election integrity case.
In her enhancement request, yes, sir.
And it wasn't in her budgetary request either, was it? Anything about election integrity?
It would have, if it was for additional resources, it would have come through as an enhancement request.
So as a commission, you weren't aware that you were funding a election interference case, certainly not before 2023, which would have been 3 years after the election.
I think that's correct.
Okay. And you haven't been given any information to tell you where the money that you did give her through Orca funds or other things were spent.
Well, whatever part of that 75 million that she received, and whether how much was used for the backlog, how much was used for the YSL case, and how much was used for the election interference case, we don't know.
Yeah.
And we're not being given any information other than with the backlog. Now,
That's insane. Why don't you know that? Why don't you know that?
That's probably easier to quantify. I don't know how she would give us, or any district attorney for that matter, would give us a report on how the case is going until it's concluded.
Understood. Yeah. But she could have told you how your money was being spent that you had awarded to her, whether it was being spent on the backlog of cases versus public corruption cases versus, Tex MacGyver or whoever. She would have been able to give you that data.
Could have, yes,
but she didn't.
Did not, and we didn't ask either.
Okay. And that's partly because she's taking the stance that she's a constitutional officer and doesn't have to give you that information.
That's probably a correct statement.
Okay. Well, let me turn to you, Ms. Joe.
That's crazy.
You and I have had conversations before today about whether or not the district attorney has to get prior
I don't even have to tell you nothing. That's
authorization of funding from the county commission when utilizing this independent contractor special prosecutor device that the legislature gave the ability through Title 15-18-20A. You heard me read that relevant portions of the statute, and you would agree just at face value that would seem to require a DA to obtain approval from the governing authority before hiring an independent contractor.
Yes, sir.
Okay, but I think make sure you're on.
I would agree that the plain language of the statute certainly seems to indicate that the governing authority needs to be consulted and approve such an appointment.
So tell us who you are. You're the county attorney. Give me just a little bit of background on you.
My name is Sue Joe, and I am the county attorney for Fulton County, which means that I am the essentially in-house general counsel for the corporation that is Fulton County. And my office handles civil matters for the entire county, provides defense and legal advice and counsel to the Board of Commissioners.
In your role as county attorney, were you ever asked to interpret this statute or do legal research to find out whether or not Ms. Willis should have gotten prior approval or whether she was required to do that before going out and hiring an independent counsel?
I don't recall if there was a specific request, but of course I keep up with current events. And when this issue came up, I did have the occasion to look into the matter and research it.
Give us your legal opinion as to whether or not prior approval is required. You've agreed that the plain language of the statute would indicate that. Have there been judicial interpretations of this statute that cloud those matters?
So let me begin by saying that the statute OCJ 15-18-20 that you were reading from deals with assistant district attorneys. So it's not explicitly giving the DA permission to appoint special district assistant district attorneys. In case law, that statute has been
independent contractors, though, right?
It does,
yeah.
which we that is the classification for special prosecutors in Fulton County in terms of how they're employed.
Is there another statute that's
so stop playing semantics then? Independent contractor, special prosecutor, it's all the same. It's all under the same umbrella. Stop playing these games with these words.
Prosecutors in Fulton County in terms of how they're employed.
Is there another statute that specifically addresses special independent counsel or prosecutors?
I have not found one. And what I was going to say is that the case law that I have reviewed that has interpreted this statute says that while it is not explicitly mentioning special assistant district attorneys, that is included in the general authority provided under the statute to district attorneys. So in at least 3 Georgia Court of Appeal cases, what I have found is that the court has rejected the proposition that this particular statute requires a district attorney to obtain explicit permission from a county prior to appointing a special assistant district attorney. And in fact, the original case. The court noted that.
Give us that citation, because
So
this
that-
is kind of instructive to the legislature. Do we need to amend this statute to clarify?
Exactly.
And so you help me with my legal research. What's that citation?
Exactly.
I'm sure the Attorney General's office would be happy to provide their official advice. But what I will, I'll begin by just saying what the citations are of the three cases that I reviewed. One of them is Greater Georgia Amusements at 317 Georgia Appeals 116, which cites to State versus Cook at 172 Georgia Appeals 433, and is referenced again in Amusement Sales Incorporated versus State of Georgia. And if you'll excuse me, let me look at my Westlaw. Okay, that's going to be at 316 Georgia Appeals 727. And all of them include a construction of OCGA 151820 that indicates the DA does not have, ADA does not have to have explicit permission from the county in order to appoint a special assistant district attorney, and that the employment may be pursuant to whatever private arrangements regarding compensation are mutually agreeable to the district attorney and the appointee. That is a quote from State versus Cook that is contained in Greater Georgia Amusements.
Okay. So judicial interpretation of our statute essentially eviscerate the plain meaning or language of the statute.
Well, I will say I was definitely surprised at the construction in that it seems to be at odds with the plain language of the statute, but that is the current state of Georgia law as far as I can find it.
And in your role as county attorney, do you seek approval from the Board of Commissioners for hiring, we'll just call them outside counsel, to represent the county's interest in certain civil matters?
Absolutely. That is considered, that travels under a separate ordinance regarding the engagement of outside counsel. So for example, it could be an official of the county is sued, requests representation. If there is some reason why my office doesn't have the capacity to take it on directly, I may recommend the engagement of outside counsel, and I will bring that to the Board of Commissioners for their approval.
Okay.
Of course you will.
And that's pursuant to a county ordinance that requires that type of approval of both funneled through your office and submitted to the county commission?
Yes, sir. The Fulton County Plan of Defense governs what types of circumstances in which we can provide defense as a county, and also the way in which that provision is made. It is either made through my office or through outside counsel. Even if it is provided through my office, I still go to the Board of Commissioners, present the case, indicate why it's covered under the Plan of Defense, and ask for authority to represent.
Is there a similar county ordinance that references or applies to prosecutors?
There is not.
So you only refer back to the state law for that?
Yes.
Okay.
That's crazy. That's crazy. All right, so I got to stop it right here, guys. I got another live to do, but I got to stop it right here because look at what's happening, right? So this is the reason why we went over the YSL case, the YSL ruling about Judge Glanville, which he is recused. But it's way deeper than just that. It's an entire system that's the problem. And so the reason why, although I'm very happy that Glanville is recused and removed, but it's in the same circuit, bruh. It's in the same county that has these corrupt financial ridiculousness. They give Fulton County money. Not Fulton, the DA. They give the DA money. They don't track it. They don't monitor it. They don't make sure it goes to where it's supposed to go to. They don't monitor the backlogs. They don't do anything. And so when you go to court, those of you that's watching this and maybe watching this later, when you go to court and somebody throw you a public defender because you can't afford an attorney, you best believe that attorney is paid by the state. That's why they only bring you plea deals. They don't give you legal advice. Let me tell you something about public defenders. They don't give you legal advice. They come at you with a plea deal. That's the first thing they do. They come at you with a plea deal and be like, you know what? The state offering you this. Do you want to take it or not? And if you say you don't want to take it, then you got to go to trial. But who's to say that the lawyer that brought it to you will be the same lawyer you're going to have in trial? So the problem is the system is broken. Glanville is a pawn. Judge Glanville is a pawn in a system. That's all he is. That's why the Supreme Court told him, hey, bro, you need to move this to a different judge. And guess what he did? He moved it to a different judge. And he canceled the schedule on Caleb Bumpus. You know why? Because he knows that the big boys told him, hey, man, we run this now. So he know he a pawn. He know it. But when you get a public defender, I'm telling you, they only there to make deals with the state. The state tell them, okay, for this particular crime, they gave you this, and this. Trust me. I'm going to be honest. I'm going to be transparent right now. When I'm not on probation no more, but when I was in court to appear in court, my public defender was a woman. She brought me a plea deal first. That's all she's, how you doing? Shook my hand, brought me a plea deal. All right. When she brought me the plea deal, it was a good one. I ain't gonna lie. It was a good one. Okay. Because I didn't have to go to jail, but I did have to go on probation. And there's certain things I couldn't do. Certain places I couldn't go and all that kind of stuff. You know what I'm saying? But that's what they do. They working with the state on your behalf. That's how they look at it. And they're like, okay, if I give you the best deal, you should take it. But if you know you're not innocent, you know for sure that you are not that you know that you're not guilty of whatever happened to you. And if you can't afford an attorney, get a good attorney. Get a great criminal defense attorney, I'm telling you. Because all the public defender is going to do is bring you a plea deal. That's what they did to the severed defendants of the YSL trial. They sent them plea deals and they all rejected them because the plea deals is like, you got to do life, you got to do years, you got to do this. What kind of plea deal is that? That's not a plea deal. That's a bow down. You know what I'm saying? So at the end of the day, man, the issue is not just Judge Glanville. The issue is the system. The system is so corrupt, it's so broken, and it's going to take, I don't even know what it's going to take to revitalize it, honestly. But what we have to do as individuals is take accountability for ourselves, take responsibility for ourselves, don't depend on nobody else to do nothing for us, and we rise in ourselves to become the best version of ourselves so we don't have to deal with none of these people because they don't have your back. I'm telling you, they don't have your back. All they're going to do is do whatever it takes to make sure that they do a good job towards the state. That's it. But when it comes to your actual freedom, they don't care about it for real. I know I'm on a little rant right now, but I got to be real with you. They don't care about your freedom like that. They don't care about your charge. They don't care about nothing. When your public defender bring you a plea deal, that's the first day they saw it. They don't know you for real. They haven't kept up with you. Nothing. They don't know you like that. The first time they bring you a plea deal is the first time they ever see you, for the most part. So all I'm gonna say to you is make sure that you're on point, stay guarded, stay prayed up, and don't get caught up in the system, man. All right. This your boy Tay Biz TV, man. I'm gonna holler at y'all in a minute. All right. Yo, if y'all like this live, go ahead, like it, share it, subscribe to the channel, man. We got more for you in a minute. Love.
I brought that with me. Case they get too easy. Baby, don't stress, don't sweat it. Put it all on my daddy. Know how I'm coming. And they know what we had. Run around through that left side. better plan these. Can't tell what they doing lately. And I'm way too clean, I'm Listerine, I thought they been knew it. All in my lungs, I got my red cup full of that in fluid. Young middle Mad Mac, I'm swinging that leg, I'm banging that do or die. And I ain't that lead before I get crucified. Living in my bloodline, this place in my family tree. How the they pressed, I did my best out of what they handed me. Straight out of that country, know my shawty dick as human air. And I need not mention no extensions, that's human hair. Boy, we grew in there. Ride through that left side, low end.